Probably heard by now that Prince Harry is in court today for a 4-day hearing, and he's not alone, and you've probably wondered what the case is all about, so I'm going to go over it very briefly in this video. You might have wondered how it differs from other aspects of data protection, and again I'll draw those differences for you. So Prince Harry is not alone in this court action today. He's with Elizabeth Hurley, Sadie Frost, Sir Elton John and his husband, filmmaker David Furnish and Baroness Doreen Lawrence Clarendon OBE. And they bring claims of what they say is a gross breach of privacy. Abhorrent criminal activity is what they refer to by Associated Newspapers Limited. Of course, Associated Newspapers deny the claims, and I'll go into that in a bit more detail. They allege that the unlawful acts include hiring of private investigators to secretly and covertly place listening devices inside their cars, inside their homes, and recorded private conversations, also accessing bank accounts through illicit means, and even paying police officials for insider information. Now, it goes without saying that Associated Newspapers Limited has denied these claims, calling these accusations preposterous smears and pre-planned and orchestrated attempt to drag the main titles into the phone hacking scandal. A spokesperson also said that the allegations were unsubstantiated, highly defamatory, and based on no credible evidence. But of course, that is what the 4-day hearing at the Royal Courts of Justice in central London is going to look at this week. Now, many of you might confuse the situation with what I've previously described as recording a conversation covertly without someone else's knowledge. Now, this is very different to secretly and covertly placing a listening device, which is what's claimed in this claim. Not that that's been decided that that's what happened yet, but that is part of the claim. Because if you were to place a listening device and pick up private conversations, not only would that be an intrusion on somebody's privacy, but then if you go on to use or publish or do anything with that information, it would be a tort of the misuse of private information. This first received main prominence in around 2014 in a case against Google. And ultimately, the test of whether this was a misuse of private information was essentially twofold. Was the nature of the information quite clearly personal information and private, over which a claimant would have a reasonable expectation of privacy? Think bank accounts, medical records, and those kind of things. And if so, is this right to privacy going to outweigh a would-be defendant's rights to the freedom of expression? So, for argument's sake, if a defendant newspaper were to come across some information and want to publish it in accordance with the Article 10 rights to the freedom of expression, would this amount to the misuse of private information if the information that they wanted to publish was something that a claimant would have a reasonable expectation of privacy about? Again, think bank statements, bank details, private medical data, visiting clinics, and this kind of thing. So if somebody were to exert their right to a reasonable expectation of privacy over that information, whereas a newspaper had published it, and it was collected covertly, secretly, or even by paying off officials in a position of power, you can now quite clearly see how this might amount to a fairly serious breach of what we'd all expect to be upheld in law. This is all very different, you understand, than just recording a conversation with somebody, for example, your insurance company, because you want a contemporaneous record of what was said during that conversation. And then you can refer to that later if you need to. For example, if they refuse to pay out on a claim, but you want to prove that they'd categorically agreed that it was to be part of your cover and later denied it, which happens relatively often, as in the dispute of that nature happens relatively often, then you can record this conversation. You can make notes, or you can actually record it using your phone and record the conversation using Memo. As an aside, we are just almost ready to launch the first version of our app Proofify, which I will link in the description below, which if you have information and you record your conversations and you've got evidence of agreements that you've made and all of these kind of things, you'll be able to save them and store them on Proofify so that if ever you need them later, you can come back to them. Because lots of people will have a photograph album full of stuff that you probably need at some point, but they get buried among thousands of other photographs. You've all got emails, but again, the relevant emails will get buried among thousands of older emails. With Proofify, you'll be able to store them all in one place and access them whenever you need to. As it progresses, we will build it out to be able to export it as a proper bundle to go behind a witness statement if ever you end up in court. This is going to save you hundreds, if not thousands of pounds. So for now, as for the case with Prince Harry in the High Court, he's not alone. Several people are coming forward to make these claims of what they call phone tapping and invasion of privacy, and I'll be very interested to see where it goes, because the simple point is this. If it is determined that covert secret devices were used and placed strategically to record covertly conversations and pick up information that is inherently private, and the court takes the view that that information is private and there is a reasonable expectation of privacy over that data, and then the court goes on to determine that this right to the privacy of that information overrides the right to the freedom of expression, which is a qualified right, it's not an absolute right, then there might well be a case for damages. Because remember, the freedom of expression is a qualified right. In this country, we don't have a absolute slam dunk right to the freedom of expression. It is a qualified right, and therefore it can be interfered with, and there can be other rights which override this right to the freedom of expression, and thus it may not provide the necessary cover if they've gone beyond the realms of what is reasonable when exposing private information. Those are the issues that the court is looking at this week. I will be following it with interest, and I will come back to you with updates as and when they unfold. In the meantime, please smash that like button and subscribe, and as always, thank you for watching.